We haven't met in person yet.
Yeah, nice to meet you.
Nice to meet you. No, I had this calendared at 1:30.
It happens.
Mm-hmm.
I get it.
It was one of those things I was sitting there, I'm like, oh, I'm actually running like really ahead of schedule today. And then I got the 15-minute reminder.
Yeah. Well, they changed the date and time.
Right, and I
So
think
that kind of, yeah.
yeah.
All rise. Hear ye, hear ye. The Court of Appeals of the District now in session. To the bill, we have state constitution and the South.
Morning, please be seated. Welcome to the First Court of Appeals. We have one case on the docket this morning. It is 01-23-00806 City of Houston versus ALEXYS SANDOVAL. Starting with appellant, will counsel please make your announcements.
My name is Kraft Hughes for the appellant, City of Houston.
Very good.
MCMULLEN for APPELLEE, ALEXYS SANDOVAL.
Very good, thank you. Does appellant wish to reserve any time for rebuttal?
5 minutes, please.
Very good. Before we begin, a couple of quick housekeeping matters. First, the lights. Green obviously means begin. Yellow signifies you have 1 minute left before the red light goes on. When the red light goes on, if you're in the middle of a question, please don't stop automatically. Finish your answer. We may ask you more questions beyond the red light. Just keep answering the questions until we tell you, until you're done. Also, we've read the briefs in the case. You don't need to do a full recitation of the facts. If you can just dive right into the legal issues, that would help us the most. So with all that out of the way, we're now ready to proceed and hear from counsel for appellant.
May it please the court. This is an interesting and unique case with, I believe, extraordinary facts that don't occur very often. In this case, a Houston garbage disposal truck was idling with a parking brake on when its driver, Mr. Kadori, got out of the vehicle, exited the vehicle, onto the street, and walked around the front of the vehicle to the other side of the street to pick up a trash can. While he was doing this down on the street, the vehicle somehow malfunctioned mechanically, jumped into gear, and slammed into two other vehicles in this residential neighborhood, and finally came to a stop when it ran into a structure, a house in the neighborhood. Now,
are there any safety standards that the city has for garbage trucks in this situation about if you stop a garbage truck and you get out of it, you have to put it in park, or is leaving it in neutral with the engine running and putting the parking brake on consistent with the City of Houston safety policies?
I do not know if the City of Houston has that policy because it's not an issue in this case. It hasn't been brought up. The point is that APPELLEE filed the lawsuit under the Texas Tort Claims Act, which is a limited waiver of immunity. And it only waives immunity for the City of Houston in situations where the vehicle, a motor-driven vehicle, is in operation or use. And our position in this case is that this vehicle was not in operation or use because the driver wasn't even inside of it.
Well, it was an operation in that it was still on and it had been placed on neutral, but the employee was operating it and it was in user operation. He stepped away from the garbage truck, but it had been in operation immediately before he stepped out. So is the city's argument, it seems to me, more of an argument of causation, whether the user operation was the cause of the injury and not so much whether the garbage truck was in use or operation.
That's a good point, and I think it's the central issue in this case, honestly. And I think it's also important for this court and all the parties to understand that, quote, operation or use, end quote, is different than, quote, the condition, end quote, of a piece of property. Now, if this vehicle had a product defect or a design defect or was in some type of abnormal condition that we were unaware of, we can't be held liable. The city cannot be held liable for a condition, a piece of property that's in a...
So you're on subsection 2 now, but I think her question was subsection 1.
Okay, I'm sorry.
No, so I understand that you're making a distinction between the malfunction maybe fitting under a condition but not use or operation. My question was, based on the evidence in the record, is there a dispute from the city that the actual garbage truck was in use or operation in the sense that it was running, it had been placed on neutral, and it had effectively been used or put in operation for an intended purpose, which was to collect the trash in this particular residential area?
The City of Houston does not dispute that that the driver, Kadori, was driving it and he parked it, and when it was parked, it was put in neutral with the engine running.
So that would be operation of the car or of the garbage truck at that moment?
When he's sitting in the driver's seat, yes.
So I guess how do you distinguish the PHI case where the Supreme Court, applying this same aspect of the Tort Claims Act held that operation extends to the end of a trip to safely securing a vehicle. And in that case, there was a truck on an incline. I think they turned the engine off, put it in park, and took the keys out. You know, here, the engine was running, it was in neutral, and the parking brake was on, and there, the Supreme Court held that operation extends to safely securing the vehicle when you're finished at the end of the trip. So how do you distinguish that from what you're arguing now?
Well, I believe the PHI case is slightly different. It wasn't a truck, it was a van. It was
Well, I mean, in terms of the holding, I mean.
Right. But in that case, the driver parked on an incline, okay? I believe a reasonable driver and probably has a duty to know that when they park on an incline, you need to put the parking brake on. Well, this driver did not do that.
But how about the holding in the case, or how about that aspect of the holding where the court held that operation extends to safely securing a vehicle? Whether it's on an incline or not, I don't think the holding was limited to parking on an incline.
Well, it's limited to well, I believe the holding is based on the facts of that case. And the facts of that case show that the driver either took action or failed to take action, which caused the incident. In this case, our driver didn't do anything to the vehicle.
Well, but is there a fact question on that issue? And how did the city meet its burden on its plea when it seems to me that the very evidence the city attached to its plea was not conclusive on the cause of the accident? I think the crash report indicated, or the HPD inspection indicated after conducting an inspection of the garbage truck that the results were unknown.
I believe it said there was an HPD inspection of this vehicle after the incident. It was removed from service. They did a report about their inspection, and they found that the driver, Mr. Kadori, did no wrong. He didn't do anything wrong. And I believe they said there was a mechanical malfunction. And it's in my brief. I can't remember if that was out of the report or if those were my words.
I remember the memos that were prepared or were presented in the record. The second memo concluded that there was a malfunction and Mr. Kadori was not at fault. The HPD report that is referenced in the crash report itself indicates that after the HPD conducted an inspection, the results were unknown. So I guess my question is, did that raise a fact issue on whether it was a malfunction or whether there had been operation negligence?
In my opinion, no. I don't believe it does create a fact issue. Because our position is that the vehicle was not in operation or use. He was in the street.
Even though it wasn't secure. So under the Supreme Court, they said operation extends to securing it at the end of the trip. And so here, the allegation as pled is that there was negligence in not securing the vehicle to a stop, that it was in neutral, and that it moved, and that there was some negligence there. And so you're arguing that the city's conclusively established as a matter of law that the only reason why the truck moved was a mechanical defect?
That's correct, Your Honor. And I don't believe it's any different than if he drove to Whataburger and parked and left it running in the parking lot to go inside and get his burger, and it jumped and hit another person or another car in the parking lot. That's just not something that the Texas Tort Claims Act was designed to waive immunity for. That is a mechanical auto manufacturer type product defect claim.
Could you tell me what the charge looks like in one of these cases if it were to go to a jury trial? What questions are asked to the jury?
For a Texas Tort Claims Act case?
Yeah.
Well, first of all, the plaintiff has the initial burden to plead and show that there's been a waiver of the immunity. So imagine the first question may be something along those lines. Has the city of Houston waived their immunity? And maybe the judge would give an instruction on that.
Is there a difference between operation and use, or are those effectively synonymous?
There's been, so there's a case called Lelo versus Hampshire Fanet in '92, that discusses operation or use, and it says the driver must have been actively operating, so, you know, all these words and terms are open to interpretation, but there have been cases that attempt to define operation and use, but none of them say the driver's out in the street when the vehicle's alone. I know that. Additionally, there's no waiver of immunity for faulty wiring. There's a good case, it's called Texas Parks and Wildlife versus E.E. Lowry. It's 2007 Texas Supreme Court case. In that case, there was a boat that was it was docked, and it was owned by, I believe, the Texas Parks and Wildlife. And there was faulty wiring in the boat, and it was left unattended, caught fire. And in that case, they said there's no waiver of immunity just for faulty wiring. And there hadn't been an allegation in this case that there was a product defect, design defect, faulty wiring, anything like that. So we haven't done discovery to figure that out. Negligent maintenance is also not considered operation or use. The case is San Antonio versus Hale in 2018. It's a San Antonio Court of Appeals opinion. In that case, they held that mere negligent maintenance of a piece of property or a vehicle is not considered operation or use under the Tort Claims Act.
Mr. Hughes, if we agree with you that the evidence established that the garbage truck moved because there was a mechanical malfunction, does that mechanical malfunction, is that a condition of tangible personal property that would allow waiver of immunity under section 0212? That would also result in waiver of immunity for the city.
If it were proven that there was some type of product defect in the vehicle, is that
Well, I think that the city's position, as I understand it, is that this was not a use or operation issue, but that the garbage truck had a mechanical failure. If there is a mechanical failure, if we agree with the city that that's what the evidence established, is that mechanical malfunction a condition of tangible personal property that would waive the city's immunity under section 101.021, section 2?
No, Your Honor, I don't believe so.
And why not?
Because when you read the statute and it says the condition of the property, that's the condition of the property as the city of Houston knows that condition to be. The city of Houston knows that their trucks in operation have been maintained, serviced, they're in good working order. So the city of Houston believes that the condition of their trucks is okay.
But you're arguing that it has a mechanical defect also.
But if it were proven, like you said, that there was a mechanical defect, that would change. It would depend on when the city of Houston knew that, honestly.
So it could, depending on the facts as they're developed. Did the city know? Did it follow proper maintenance? Was
Correct.
it inspecting its garbage truck?
Correct.
Could you remind me, was there an oral hearing on this in the trial court on your plea?
On the summary judgment, I think it was a summary judgment. I don't remember if it was an oral hearing. And I have a little over a minute left. If you have any other questions, I'm happy to answer.
Any further questions?
No.
Any further questions?
Okay.
We appreciate your argument.
Thank you.
We're now ready to hear from counsel for APPELLEE.
May it please the court. I think several of the positions that I was going to talk about have already been addressed in questions directly asked by this panel. Ultimately, the issue in this case, I agree with Mr. Hughes, is something that doesn't happen all that often. This is an unusual set of facts, but there are reasons that there is a waiver of immunity for the government when something unusual like this does happen. In plaintiff's first amended petition, she did allege both waivers of immunity under the use of a motor vehicle and under the condition of tangible property. The statute does not say must be either or, and there is no exclusive bar saying that plaintiff cannot plead them in the alternative. There is a case, Miranda, that says that the tangible personal property waiver cannot be brought in conjunction with a premises defect case, and that is because premises defects have a higher standard of care owed to a licensee. Here, that's not the case. They may be pled and have been pled in the alternative.
I have a question about the
Yes.
decision tree. Just pick one as a hypothetical. If you're right about the first one, do we need to, or should we reach the second one, and vice versa?
I don't think so here, Your Honor. I think that there is a fact issue that Justice Rivas-Molloy brought up earlier, that is there a malfunction or is there not a malfunction? Is it the vehicle in use or is the vehicle not in use? Those are both fact questions that could be asked to the jury in the charge. The first question that the jury would be asked is whether or not there was a valid waiver of immunity. The answer to that question, regardless of if it's under subsection 1 or subsection 2, that answer would be yes. Move on to the next question. With respect to the question that you asked earlier, Justice Gunn, about if use or operation of a vehicle had distinctions, the PHI case actually does go into the distinctions between use and condition or operation. Very similar, but use is to put or bring into action or service, or to apply for a certain reason. Operation is referred to as doing or performing practical work. Mr. Cattery was driving a garbage truck. He was picking up the city of Houston's waste. He got out of the vehicle, allegedly put the vehicle in park, and was going to upright a fallen truck, a fallen can. I think it would fall under use because the vehicle was being put in use to perform a specific purpose. It was transporting a garbage collector to do his job, and he was getting out of the vehicle to continue doing his job.
Ms. McMullen, how would you address the city's position that all of these cases consistently hold that the use or operation must be active? In other words, there has to be an active use or operation. As I understand Mr. Hughes' argument, you have to have the driver behind the wheel, or there has to be some sort of active operation. Here, there was no active operation the minute the driver stepped away from the garbage truck. Can you address that?
Yes, Your Honor. I think that that question is pretty much directly addressed in both the PHI case and this court's Branch decision from earlier this year. Those decisions are consistent with the fact that the vehicle does not need to have a driver behind the wheel at the time. I think PHI is directly on point when it comes to there is an obligation for all drivers to make sure that their vehicle does not roll away when they leave the vehicle. Branch is also partially correlative, not completely on point, because in that case there was a motor vehicle that lurched forward when there was no driver in the vehicle. However, that case was a little bit different because there was in fact a passenger in the vehicle versus the vehicle being completely unoccupied. But I would say that PHI is more on point. Not only was a vehicle left allegedly in park and the vehicle rolled away into a piece of property in the Appellee's case, her home, in PHI into a helicopter. The vehicle was left unoccupied, the vehicle was allegedly put in park, and the vehicle moved forward without a driver behind the wheel.
Since it's past 11 in the morning, it's hard to leave the Whataburger hypothetical alone. I think we really need to talk about that. Would you please comment on it?
I apologize, Justice Gunn. The Whataburger hypothetical.
Yeah, the example that the appellant gave of the vehicle being parked, say at lunchtime at the Whataburger, and then say it rolls or either the driver's not there. So we're trying to figure out the boundaries of operation and use.
Sure, I would echo Justice Rivas-Molloy's point earlier that this vehicle was still on. It had been put in neutral and the parking brake allegedly engaged. Let's say a Whataburger hypothetical. If I go to Whataburger and I park my car, I park it and I turn it off, I believe that would what would be extinguishing of the use or operation. But in this case,
But wasn't that the case in PHI though? I mean, he turned it off and he took the key with him, put it in park and turned the engine off in PHI, I believe.
But yes, Justice Adams, I would agree with you on that. However, in this case specifically, Mr. Cattery was continuing to perform his work. His work had not extinguished. He planned to go get back into the vehicle. Let's say for Whataburger, I'm driving, just to go get lunch. I don't have anything to do other than going in, getting my lunch, getting back in my car. I'm not using my vehicle for a government purpose. I'm not going to pick up lunch for my boss, who happens to be the Chief Justice of the Appellate Court. I'm just going for personal reasons.
Yeah, and the idea of use, I mean, tell me if I understood you right, that you were suggesting use is more than simply transportation from place to place, that this machinery allows, say, a claw to grab a can and to put it in, and I take it even when it's sitting still, your position would be that's using the vehicle because it's collecting the trash.
I would agree with that, Justice Cohn. And just for a little bit of further distinction between this case and the Branch case, this was a city vehicle. There's no contention that this was a city vehicle. It was not a personal owned golf cart as it was in Branch. This was being used for the specific purpose of picking up garbage. It was what it was supposed to be doing. And I think that there is a line in PHI that was then adopted in Branch that is instructive here. It's that common words like use and operation shouldn't be given these complex legal terms of art. They should be sort of evaluated from their common parlance. And I believe that a garbage collector driving his vehicle, knocking over a garbage can, getting out of the vehicle to pick up the garbage can with the intention to complete his route and continue going on that in the vehicle should constitute the use and operation of that garbage truck. And to the point of the alternative pleading about the malfunction, the city is saying that it can't be use of a motor vehicle because there was a mechanical malfunction, but also it can't be a condition of a vehicle for purposes of subsection 2 because the city didn't know about it. I would say that there is a distinction in what constitutes a condition. It doesn't necessarily have to be with the knowledge of the city. The Sampson versus University of Texas at Austin case says that condition is an intentional or an inadvertent state of being. It doesn't have to be one or the other. And
so Ms. McMullen, just to make sure I understand, so I follow what you're saying, but the distinction is the malfunction. If it was a malfunction, then it fits within the condition under subsection 2.
Correct.
If it's use or operation, it would fall under subsection 1, waiver of immunity. So either or, your position is there's a waiver of immunity here.
Yes, Justice Reeves-Malloy, and I would say that to your earlier point about whether or not there was a fact issue about if there was in fact a malfunction or an issue with the parking brake, there is a distinction in the record. There's a report from the city that says that the cause of the accident is undetermined, and then there is the police report that says that there may have been a contributing factor of inadequate or unused brakes. Then we have Mr. Cattery's statement that says that he put the vehicle in park and it took off. We have multiple different accounts or sort of causes that could be attributed to the wreck, but none of them are definitive. That's a fact issue. That could be for the jury.
Can you remind me what stage of the proceeding the plea had been filed? Had the plaintiff already engaged in discovery, or was this filed very early prior to discovery?
Speaking of this case, as there were some unusual things, there was counsel with the city that was swapped out as we were in the middle of discovery. Once this counsel had been swapped out, the motion for summary judgment was filed. We filed a motion for continuance in order to conduct additional discovery, including the depositions of Mr. Cattery and Mr. Cattery's supervisor, who signed that report that said it was undetermined. We were granted that motion for continuance and did ask the city for depositions on 4 occasions that were in writing and several occasions on the phone that I didn't record down. We were not able to get those depositions. We did unilaterally notice the depositions. And
you drew a motion to quash?
We drew a motion to quash, yes, Your Honor.
And then was there a hearing on the plea?
There was not a hearing on the plea. This was done by submission.
Can you address the alternative theories of negligence? Why do you get to keep the failure to train, supervise, enforce adequate workplace safety standards, and failure to maintain vehicles? What waiver of immunity would allow the plaintiff to pursue those avenues?
I would agree that the failure to train, supervise is not valid under the waiver, so those would be rightfully struck. However, I believe that the maintenance does go to the condition of the vehicle. We have specifically pled in our first amended petition that this was either or. The statute does not say or, it does say and. So I believe that the allegations of failure to maintain do implicate the condition of the vehicle and whether or not the vehicle was in proper condition under subsection 2. I
was going to suggest to you some of those tag-along claims look like they just can't get there, but we can just move on now.
We can move on, yes, Your Honor. And I believe I've addressed the questions that came up earlier. I know that the court has reviewed the briefings. Just in general on this case, echoing the sentiment of PHI, keeping the legalese out of it, for lack of a better term. My client, the appellee, was asleep in her bed and a City of Houston dump truck ran into her house. And the city's contention is that not only was that vehicle not being used in order to provide waiver under the TTCA, but also that if the vehicle did malfunction, that was not a condition that would give rise to a waiver of immunity under the Tort Claims Act. I believe not only are those positions a little bit opposite of each other, either there's a malfunction or there's not a malfunction, that would give rise to the waiver, but ultimately, but for the negligence or the lack of care on the part of the city, my client's house would not have had a dump truck run through it.
Would you like a chance to respond to the E.E. Lowry case that we heard cited by the appellant?
The E.E. Lowry case was the one about the wiring of the boat. That's right? That's right. So I would say that that case is distinguishable from this case here. The wiring of the boat was left at a separate place and the city left. The boat did not move. The boat did not continue operating. The boat was definitively not in operation. It was parked and there was no one there. And then the faulty wiring did cause a fire and did cause injury after the fact. I believe that the phrase that's used for use of a motor vehicle is nexus or locus of the actual use of the vehicle. I believe in this case we do have a tight nexus or a tight locus of the vehicle's use, whereas in E.E. Lowry that was not the case. If nothing further, thank you, Your Honors.
Any further questions?
No, I'm done.
We appreciate your argument. We're now ready to hear a rebuttal argument from the appellant.
In the PHI case, I just looked real quick. One of the initial items that the opinion talks about is that PHI must prove or establish that their damages arose from the driver's failure to set the emergency brake. That's the first thing that must be proven in the PHI case. Now, in this case, first of all, the damages to the property and the house and the cars that was caused did not arise from anything that our driver ever did. He simply exited the vehicle and was walking on the street. None of his actions caused, or the damages did not arise from any of the driver's actions.
So, but PHI also, at least for the operation component of 1, says operation of a vehicle includes making sure it does not roll away after it is parked.
That's right.
And so you're arguing here that the evidence conclusively establishes that they satisfied that?
Yes, Your Honor, because not only does it conclusively establish it, it goes even further. Our driver set the parking brake. He set the brake. That's in the record. He did everything a reasonable driver should have done in that situation. And And also, there's been some hypotheticals thrown out today. I'd like to just...
And so he set the parking brake, so basically it goes back to the active argument that he wasn't actively engaged in the vehicle. Is that the gist of your argument?
That's one argument, but it also includes the arises from. The damages have to arise from the driver's actions or inactions. And I don't think we have it in this case. Additionally, the city of Houston has, I want to say like 20,000 vehicles, something like that. And hypothetically, if let's say 10,000 of these vehicles are Fords, and 10,000 of these vehicles are these public works dump trucks, okay? And all of a sudden, Ford has a massive recall for their transmission that suddenly jumps into first gear unattended. And this happens to 10,000 vehicles in Houston. Now, I don't think our legislature passed the Texas Tort Claims Act to waive immunity in situations like that. I don't think the city of Houston should be liable for a massive recall that causes damages when the city of Houston had nothing to do with it.
Was there a recall here, though?
No, this is a hypothetical.
Okay, hypothetical. So
yes.
In the hypothetical, there would be, but which is different than this case.
I haven't checked to see if there's a recall for this specific model truck, because we haven't got that far in discovery.
Right, but it's not in the record.
It's not in the record.
Yeah.
That's it.
The active argument, do we have to read language into the statute to get there, or is there a case that supersedes the statute that allows us to read that word into the statute?
I believe arose from.
No, active.
Oh, active.
Yeah, the active.
No, I think that's from the PHI case. It's from the case that I quoted. Let's see. It was from the Lelou versus Hampshire Fennett Independent School District case. I think that word active was just used in that case. And once again, negligent maintenance has already been held to be not operation and use by the San Antonio Court of Appeals.
That's the Hale case you were talking about.
Yes,
Right.
yes. I believe that's all my points that I have right now.
Any further questions? Any further questions?
No.
I appreciate your time.
We appreciate your arguments. We appreciate both of your arguments today. And with that, this case is submitted, and we are adjourned.
Thank you.